Good morning, everyone. Hope you're all well. Um, right, today we the what we're going to be covering is the contractual capacity of natural persons. So today is a pretty much a back to basics day, so that we can just try and understand contractual capacity. And then what I'll probably do next month is if there are no objections, I'll look to doing the contractual capacity of companies, closed corporations, and trusts. So of course, from my point of view, contractual capacity is absolutely critical, and from your point of view as well. And just understand, guys, that you know I never underestimate the ability or the capacity of sellers and purchasers to be nefarious and to deliberately do things which will stymie the deal or to create a second chance for them somewhere. And I think we owe it to ourselves, and we owe it to our sellers and the buyers to make absolutely certain that when we enter into an agreement to sell, that those parties have the correct contractual capacity, because there's a bunch of consequences that flow from getting it right. So it might be a massive delay in the transaction, or it might be that the transaction is not valid. And also please bear in mind that we have calls from people on a regular basis saying to us, I've entered into an agreement, I now no longer want to buy, or I no longer want to sell. My situation has not changed. For whatever reason, they say to us, please try and get me out of this agreement. So that's why it's important for us to get your contractual capacity right. And also to remember, guys, in terms of a process flow from you guys, you put so much effort into, and particularly in this market, into finding the property, listing the property, marketing the property, taking all those buyers around the property, potentially bringing the seller down to a realistic price, a relative price point, getting the buyer and seller to agree, and now you conclude this agreement. And you've inspired the confidence of the parties to conclude the agreement, and you've potentially earned some commission. And it's such a negative to have that, to have that transaction stymied because we didn't pay attention to contractual capacity, and the whole thing falls flat. And suddenly, our sellers want to use somebody else to remarket the property. Our buyers are going to buy somewhere else, and it becomes what was a positive is now a negative. So let's go through the next few slides. Everything that I'm presenting to you here is in my property law manual. There's an article, two articles on this, so you're welcome to have a look at that as well. And in fact, the article is drawn in such a way that you can use as a reference point if you can't get hold of somebody for advice if you need it. Okay, so first things first, right? Anybody over the age of 18 years has full contractual capacity, can contract can contract exactly as they are unassisted. So if you're 18 years and above, you have full contractual capacity, do as you please. Then you've also got various before I go into the marriages, I just sort of stop and pause on this point and say to people, you need to have basic contractual capacity. So even though you're at the age of 18 years and above, you need to actually have contractual capacity. And what I mean by that is you need to have the ability to understand the contract that you're entering into. So, for example, if you go to someone and they are absolutely blind drunk, right? They are blind drunk. I would walk away and come back when they're sober, because the question is, if you're so drunk, if you have a beer too, no problem. If you're blind drunk, do you have contractual capacity, the mental ability to appreciate the nature of the contract that you're entering into? Maybe not. Becomes arguable, and we never want to have to argue around these issues. And then, of course, the other more common category of contractual capacity or mental capacity is, we have people who are either ill or aged. And these people, we need to make sure that when we contract with these people, they actually have the ability to understand the nature of the contract that they're entering into. So, for example, I might find somebody who has Alzheimer's or has dementia, and that person may have lucid moments in the morning where they understand what they're doing, and that's fine. Maybe we can go and meet with them and their doctors and their healthcare practitioners, and we can sign the contract whilst they understand. But they maybe also be at a stage where they have no contractual capacity. They're not able their disease is such a stage, or their age is at such a stage where they are not able to appreciate the nature of the acts. And I think, guys, we must be very, very careful when dealing with these types of issues. And unfortunately, you know, and in practice, can I say this, that in practice, we have a family member who arrives and they say, well, I have a power of attorney to act for my mom, or I have a power of attorney to act for my spouse. So I'm going to use this power of attorney. Guys, the reality is that a power of attorney is only valid for so long as the person who granted it has the mental ability to revoke it. So if I give you a power of attorney today, and then my disease of dementia, advances to such a stage where I can no longer appreciate the nature of my acts, I no longer have the ability to withdraw the power of attorney I gave you, that power of attorney now becomes invalid in law and can't be used. So the temptation still is sometimes to use that power of attorney, even though the person can't, even though we know in law it's invalid. There's a temptation. And what I'm saying to you guys is we must resist the temptation. And the reason why we resist the temptation is because we don't know what people's circumstances are. So you might be there with the person's mother might be there, and they may be they may be having an issue with contractual capacity. So one of the kids comes to you and says, listen, we need to sell my mom's house. My mom gave me a power of attorney, and I can use the power of attorney to sell the property. The mother doesn't have the necessary contractual capacity, but you go ahead notwithstanding that, and you find a conveyancer who's going to transfer the property for you. The problem with that is we don't know what their circumstances are. Is there another? Are there a whole bunch of other siblings? Are there other family members who have some kind of interest in the property? Now the property's been sold, we transfer the money into the seller's account. Somebody's got control over it. What I'm saying to you is, we have people coming out the woodwork to point the allegation at us to say, how did you sell the property? How did you transfer the property? I mean, a great example that I had a couple of years ago was, and I think I probably told you the story before. Agent came to me and said, listen, I've been marketing this property. The seller wanted 4 million rand. He's now gone into a coma. He's in hospital. His wife is a power of attorney. His wife's prepared to accept 3.2 million. I said, absolutely not. You can't accept an offer to purchase, because the seller who's in a coma may come out the coma. Now you sold his property for 3.2 million rand. He still wants 4 million rand, and now he's going to sue you for 800,000 rand, because in his mind you've lost the money for him. So this person has the chance to recover. Maybe people with dementia won't recover. The point that I'm trying to make is, guys, be very, very cautious. Now, what are the alternatives? Let's say we're dealing with someone who has dementia, power of attorney or no power of attorney. What do we do with these people? How do they sell their property? Well, there's three options, right? The first option is this. The first option is, unfortunately, what we need to do is allow time to pass on, and they die. Because once they die, their property falls into a deceased estate, an executor is appointed, and then the executor deals with the property. Of course, not everyone who's in the stage is close to death, so we need to look at the other two alternatives. The second alternative is have a curator bonus appointed, and a curator bonus is a high court application, a two-phase application. It can be quite expensive, and it can be quite time consuming. Then what we can do is we can have an administrator appointed in terms of the Mental Health Act, and that's an application to the Master of the High Court, which is more cheaper and is more time effective as well. Okay, guys, so that's the first thing. Who you deal with, they must have actual contractual capacity. Then we have unmarried adults. So we have persons who are unmarried and above the age of 18, full contractual capacity. Then we have unmarried adults, right? So an unmarried adult is someone above the age of 18 who is now married. Now, we need to look at the different kinds of matrimonial property systems in order to now determine whether or not these people have got contractual capacity. And it is really important to find this out. So in our law, we actually have three matrimonial property regimes, right? We have in community, out of community with accrual, out of community without accrual. Now, for our purposes, we're not worried about the accrual system at all. The accrual system doesn't impact us. The accrual system only arises on death or divorce. For our purposes, if you look at the screen in front of you, We got married out of community property, or we have married in community property. Okay, so in order to be married out of community property, what you must do is you must enter into an internuptial contract before you get married. If you enter into an internuptial contract and it's registered in the deeds office, you then become married out of community property. And of course, that ANC, you choose whether you have the accrual or not the accrual. But as I say, it doesn't matter for our purposes which it is. If you do nothing when you get married, um, and you don't sign an ANC, you will then be married in the community of property. Guys, please understand that there's loads of people out there who don't understand how they are married. They just don't understand it. And that might sound surprising to you, but believe me, people don't really understand the niceties of these things. And you know, sometimes it was a long time ago as well. So maybe it's not important to them anymore. If you are married out of community of property, you have two separate estates, and therefore you have contractual capacity to contract on your own without the assistance of your spouse. If you are married in community of property, you didn't sign ANC, you got married in community property, you now have one joint estate. So what happens is, if I got married in community property with my spouse, everything I owned before the marriage, everything Sheba owned before the marriage, we put it together. We now own it jointly and severally. All our debts from before the marriage are also put together, and we now have those debts jointly. Guys, this is where it becomes important. You do a deeds office search on every single property transaction that you do, and you establish, you're trying to establish from the deeds office search, how are these people married? We have seen cases, guys, and just consider that this as an example. I'm sure I've told you this before as well, but let me just repeat it for the sake of clarity. I'm a single guy. I go and I buy property and I register it in my own name. Okay. I'm an unmarried adult. I buy property. It's in my own name now. If you do a deeds office search, it shows my name. No problem. I own the property. Now what I do is I go and I get married in community of property. Okay. Once I'm married in community of property, my wife-in-law becomes a half share owner of the property. But if you do a deeds office search, it's still only in my name. If you pull my title deed, it's still only in my name. But the law is such that because I'm married in community of property, I now still need to have my spouse sign any sale agreement to sell their property. Because even though my wife's name is not on the title deed or on the deeds office search, in law, she's a half share owner of the property. And remember, in terms of Section 15(2) of the Matrimonial Property Act, if I'm married in community of property, I can't buy or sell property without the consent of my spouse. Consent for the purposes of the deeds office means she must sign the offer to purchase and sign the power of attorney, right? So I absolutely need to know that my spouse is around and is going to be able to do this. If my spouse is not going to sign, I don't have a deal. Okay. So this is why it's so important to do the deeds office search and ask the question, how are you married? Okay. How do you test how someone's married? Well, you can do a deeds office search in every single deeds office in the country and see if there's an internuptial contract registered. If there isn't, you're in community. If there is, you're out. Remember, if you do this exercise, bear in mind that, if I'm married, ANC, and I get divorced and I get married again, my old ANC is still in the deeds office. It doesn't disappear because I got divorced. So don't just make sure it is the correct the correct the correct ANC that we're looking at. And Joanne says you look at their smile. That's also very true. Well, true in most cases anyway. All right, guys. The next category of married persons that I want to look at is persons married according to Hindu or Muslim customary law. Okay. So what we must remember is that we have the Marriage Act, and if you get married in terms of the Marriage Act, it's what we call a civil marriage, and it's in or out, in a community, out of community. Those marriages are recognized in our law because they are in terms of the Marriages Act. Okay. If, however, you are Hindu or Muslim and you get married according to the Hindu or Muslim customary law, to date, unbelievably, these marriages are not recognized as civil marriages in our law. They're still customary marriages. And because they're customary marriages with no legal recognition, our law doesn't recognize them as marriages. All right. So until a recent constitutional court case that dealt in depth with these types of marriages, we had a choice. We could describe that person as married according to Hindu or Muslim rites, or we could call them unmarried. This court decision said we may not call them as unmarried because they're not unmarried. They're married according to Hindu or Muslim customary law, right? But because they are not recognized in our civil law, okay, they're the same as being married out of community property. They have full contractual capacity on their own to enter into a contract. They don't need the consent of their customary law spouse. Bear in mind, guys, there is legislation coming. This is an issue that our legislature has been dealing with for a very long time. It's the same as black customary marriages. They're going to regulate Hindu and Muslim customary marriages, but it's not a simple thing to do. But the law, there are changes on the way, and they've been on the way for a while. So let's talk about persons married according to the laws of another country. And I just want to make something absolutely clear. There's an assumption that goes around that if you married according to the laws of a different country, right, then you married in community property. Or some people think you automatically married out of community property. That's not true at all. Okay. We must not think about foreign marriages as we think about our local marriages. We must say, if you married according to the laws of a foreign country, how are you married? You married according to the laws of a foreign country. That's how you're married. We're not going to classify you as in or out. So you must understand this: the deeds office will view all foreign marriages as potential in-community marriages. And what this means is the deeds office says, right, we don't know the marital law of every other country in the world. And it's impossible for our deeds office to keep up with the law in every other country. So if you come from Venezuela, are you in or out of community property? If you're married in Botswana, are you in or out of community property? Um, how do we treat the proprietary consequences of your marriage if you're married in China? We don't know, and it's impossible for us to find out because there's so many variations of laws over the around the world. And I think that, for example, I think it's Mozambique, one of those countries. You're deemed married out of community property for everything else, for everything, but in community property for immovable property. So it has complications. So what our deeds office says is, we're going to you call people who are married according to the laws of a foreign country, you call them married according to the foreign law, and we treat them as potential in community property marriages. And what that means is the deeds office says, listen, we're going to treat your marriage as if it could be in community. So we're going to always make sure that the spouse of a foreign marriage is aware of what's going on. And we're going to look at the potential plus and negative sides. Okay, so let's see what this means in terms of practical terms. Divided into selling and buying. If you're married according to the laws of a foreign country and you're selling, okay, and bear in mind, guys, of course, if myself and my spouse both own the property, well, we'll both sign the offer to purchase, we'll both sign the documents. This applies if one spouse owns the property. So if you're selling your property as a person married according to a foreign law, well, then the question arises, do I need my spouse to sign? And the way the deeds office treats this is the deeds office says, and I'm going to use the husband. The husband owns the property. We want the wife to know that the husband is disposing of an asset in the potential joint estate. Therefore, we want the wife to sign a document that says, I'm assisting my husband to sell, because in that way, the wife knows the husband is selling. And if she doesn't want to sell, well, then she can raise an objection. She can say, hold on, I also own half the property in our law, therefore I don't want you to sell, therefore I'm going to stop you. So what we want to do is, when it comes to conveyancing, so the sale agreement doesn't need to be signed by the spouse. It only signs by the spouse who owns the property. The additional spouse doesn't need to sign, although I really gives me great comfort when I see the other spouse sign the offer to purchase, at least as a witness. But they're not a party to the agreement in the sense that their name is not on the agreement. It's only the actual owning spouses on the agreement. Okay. Then what happens is, when it comes to conveyances, the additional spouse the assisting spouse signs the power of attorney. So it's Maurice van Rensburg, married at the court of the laws of the United Kingdom, assisted by his spouse, Tamarin van Rensburg, insofar as needs be. And it's insofar as needs be because we don't know how much assistance is actually needed. Okay, so guys, sometimes also what happens here is that we come across a seller who wants to sell, and they say to us, look, my spouse won't sign. My spouse hates me. They won't sign, and therefore I need some assistance. What we can do is we can get an opinion from a local university, and that local university is going to tell us what is the law in the country of origin, and we can take that opinion, give it the deeds office, and the deeds office will then say, cool, well, we don't need the spouse to assist because in that country of origin they married out of community property. When it comes to buying, guys, if no bond is taken up, no spousal consent needed. Where a bond is taken up, in order to register the bond, the spouse must assist. Okay, again, because if there's a potential debt if there's an actual debt in a potential joint estate, well, then the spouse needs to know that the buying spouse is creating this debt. Okay. Non-residents, guys, at this stage, non-residents have full contractual capacity to buy and sell property. Of course, there's certain restrictions on how much bonds they'll get, and you can chat to Suzette about those. I'm sure she'll give you the exact details on what kind of bonds they can get. But for right now, in terms of buying and selling, there's no restrictions. Customary law marriages, guys, customary law marriage can become extremely complicated. So I'm going to give you the very simplified version. Monogamous customary marriages before the 15th of November, okay, are deemed to be in community property. All right. So we had the Recognition of Customary Marriages Act, which was enacted on the 15th of November 2000. After the 15th of November 2000, we treat customary marriages, and when I say customary, I'm saying monogamous customary marriages. So I'm struggling with that word. Monogamous customary marriages after the 15th of November are treated like all other marriages. If you enter into an ANC, you're out of community. If you don't enter into an ANC, then you're in community property. If there's going to be a marriage with more than one spouse, it needs to be regulated in terms of a court order. If you have issues in regard to these, please come and chat to us. Civil unions, these are gay marriages, and we've had the Civil Unions Act. So now that we have the Civil Unions Act, again, they're treated as civil marriages. They're recognized in terms of our law. If you enter into an ANC, you're out of community property. If you don't enter into an ANC, well, then you're deemed to be in community property. Okay, same as normal straight marriages. The same rules apply for gay marriages. Okay, minors, again, guys, be very, very careful when it comes to minors. If you list a property and you see that the owners of this property are below the age of 18, please go and speak to your principal and devise a strategy. And I'm saying this deliberately. Don't go and discuss with everybody else. Go and talk to your principal and devise a strategy to sell this particular property. Okay. So minor is somebody who's below, anyone below the age of at the age of 18. It used to be 21, but now it's 18, right? For the last, well, since the dawn of democracy, I think it's at the age of 18. So when a minor, so first of all, can I say this? If a minor buys immovable property, I can register property into the name of a minor, no problem, right? The child can be 2 years old, as long as their parents help them to buy the property, and as long as they pay cash, I can transfer the property into their name. So it'll be Marius van Rensburg, an unmarried minor, and now this 5-year-old now owns property, no problem. Okay, is it a good idea? It's not a good idea. If that minor wants to take a bond, master High Court consent if it's less than 250, High Court consent if it's above 250. In my conveyancing time of 25 years, I've never ever seen this happen, so I wouldn't worry about it. If people want to buy property into the name of a minor, again, please speak to your principals and devise a good strategy, because it's not a good idea. If the child's 17 years old, no problem. If the child is 5 years old, yes, there's a problem. And the reason why there's a problem is when a minor wants to sell property, if the property value, if their share of the property value is less than 250, I need the consent of the master. If it's above 250,000 rand, I must bring a substantive High Court application to get permission from the master to sell, from the High Court to sell that property. So it costs you 35 to 50,000 rand. It's going to take you 6 months, 4 to 6 months at least. So it's a hell of a process. And this is why if we come across these people, we should rather say to them, guys, rather buy the property into a company or a trust, or let's do something else. Insolvents, guys, and you can sometimes see this from the deeds office searches. um you can't let an insolvent buy or sell property without the assistance of the trustees. So insolvents are people who've been declared by the court to have been sequestrated. Their estate is taken out of their hands and put in the hands of a trustee to be managed by someone else. Okay, guys, so there's one last point I want to cover, and that's the kind of extent of matrimonial property. Of contractual capacity for individuals. So I just want to talk about one last thing, right? 4 minutes, so I'll try and do it pretty quickly. What we have to do, guys, is when we, and again, if you need help on this, please do give us a call. There's something called domicile, right? And domicile, the law of domicile determines which country's laws apply to your marriage. Now, this is really important because if you're married in South Africa, right? If you're married in South Africa, well, then you either married in community property or out of community property, and then you either do need your spouse assistance, i.e., in, or you don't, i.e., out. Okay, and that's easy enough. But if the domicile, if the law of domicile determines that you married according to the laws of a foreign country, well, then the foreign country's laws apply to your marriage. And then again, you have now different restrictions on mortgage bond applications. You have restrictions on whether the spouse must assist you in selling and buying. So it does have quite an impact, and we see this coming across, fairly regularly. So what is domicile? Domicile is and there's actually something called the Domicile Act, right? There's a Domicile Act, and the Domicile Act says that everyone above the age of 18 has a domicile. Okay, so the domicile is, where I'm lawfully present, and where I have the intention to settle there for an indefinite period of time. So it's a bit of a mind space gray area type thing. I can change my domicile. So, for example, I'm living in South Africa. I now move to the UK, and I now decide I'm going to live in the UK permanently. I've not changed my domicile from South Africa to the UK, and I now live there. So let me just give you an example as to how. I'm sorry, this is really important, and it's a bit sexist, but the way the law is currently structured is that the domicile of the husband at the time of the marriage determines which country's laws apply to that marriage, right? So it's not the domicile of the wife, it's the domicile of the husband. So the question is, what am I treating as my permanent home? So let me give you an example. Mr. H is a citizen. He meets Mrs. W, who's an American citizen. Okay, he takes up a 6-month contract in London because he wants to get a bit of experience. So whilst in London, Mr. H and Mrs. W decide that they're going to get married, and they get married, and they receive a British marriage certificate. Okay, so the question then arises: do the laws of South Africa apply to their marriage, or does the law of the United Kingdom apply to their marriage? But now we have two different scenarios. Number one, if Mr. H went to the UK and he was only there for a 6-month or a 1-year sabbatical, or to get some experience, and he always intended to come back to South Africa. So in other words, South Africa remained his domicile. He was only in London temporarily. Well, then the law of South Africa is going to govern his marriage. And in that case, he's married according to the laws of South Africa. And then we're going to say, well, did you enter into an ANC? Yes. You're out of community property. Did you not enter an ANC? No. Then you may be married in community property. If, however, his intention was, I'm going to move to London. I'm going to remain in London permanently, and then he got married to Mrs. W. Well, then the law of the United Kingdom applies to his marriage. Okay, so you can see how this calls for a little bit of speculation. And we sometimes sit down with clients and say, listen, what is your intention? It's really important as well that we don't just go into some nonsense and say, well, what suits us better at this stage? Because I mean, consider the scenario of Mrs. W, right? If Mr. H decided, or if Mr. H and Mrs. W decided it was more convenient for them to be married according to the laws of the UK, well, then potentially in the UK they're married out of community property. Now, Mr. H and Mrs. W have two separate estates, but if the real facts were that Mr. H was actually domiciled in South Africa at the time of his marriage, even though it happened in the UK, and he didn't enter an ANC, well, then Mrs. W is entitled to 1/2 of Mr. H's estate. And if he, for example, become a very, very wealthy man, well, then she's entitled to half of his money. Now, you can see how by choosing a matrimonial, a domicile as either being the UK or South Africa, there has very big proprietary and financial consequences. And that's why it's really important to get this right. So again, I know that's a little bit confusing. It's all in an article that I've written. Please do give us a call if you need some help with it. And that's, guys, that's it. So I'm done. Thank you very much. I see I've gone 1 minute over time. Apologies, Michelle. What happens, the one question I've had, what happens if there's a gay marriage? Well, the gay marriage, as I said, is covered by the Civil Unions Act. So for gay marriages, they must do the same as straight people. If they want to be married in community property, do nothing, just get married. If they want to get married out of community property, well, then they must enter into an ANC, the same as straight people do. They must enter the ANC and they must then marry out of community property. And they can choose the accrual system or not the accrual system. So guys, I think that's a good summary. A gay marriage, yeah. Sorry, Shirley, you're quite right. In gay marriage, in regard to domicile, I've had it before, and what we did, and you're quite right. There's a bit of a lacuna in our law, because in a gay marriage, if the law of domicile is such that we choose the domicile of the husband, well, now we have potentially two husbands, or two wives, as an example. What I did was, in my one particular case that I had, I sat down with both parties. I explained what the law was, and we made a decision to choose the domicile of one of the husbands. But the parties understood that they were going to have to follow that going forward, and it wasn't a choice that they couldn't reverse their positions on it. But there is a bit of a lacuna there. You're quite right, and the same would happen with gay marriages where you have two wives. The same thing would have to apply. But I don't know that they've updated the Domicile Act to cater for this exact circumstance. Okay, guys. And here's Michelle, just in time.
Thank you, Marius. I was just waiting for you to finish answering all the questions.
Cool. Right. Well, thank you very much. Thanks for the opportunity, guys. And yeah, good luck out there. Thanks so much for all the support we get. We absolutely 100% appreciate it.
Thanks, Marius.
Thanks always
for your input.
See you
Cheers.
soon.
Have a good day.
All right. Thank you, everyone.
Bye.
Bye.
All right. Good morning.